Hello everyone, welcome back to the channel Ajay Sharma law. So today we are going to discuss one of the most important case law in the company law, Salmon versus Salmon, 1897. So let's understand the story first. Mr. Salmon was a businessman who making the leather boots, and he decided to register his business as a company called Salmon and Company Limited. In his company, he included his wife and children as shareholders. He himself had most of the shares and also became a debenture holder. But soon the company suffered heavy losses. That's why he discussed with the liquidator and want to wind up that company. And when the company was liquidated, the creditors demanded that money. Salman himself should be personally liable. That's say by the creditor, and whose person was creditor are basically those persons who demanded their money from the Salman. And Salman himself should be personally liable for all the company debts because according to them the company was nothing but his agent. But the legal question is there: is a company after incorporated separate from its member, or is it only an agent of the owner? So let's we discuss about the held of that the held which is given by the House of Lords. So firstly, we read out with the facts. Mr. Salman, a leather merchant, incorporated his business into a company, namely Salman and Company Limited. With himself, his wife and his children are as a shareholders. He held that the majority of share and also become a secured debenture holder. Subsequently, the company went to into liquidated. So basically, ये जो फैक्ट है ये बात करते हैं कि जो मिस्टर सालमन है वो पहले उनका एक बूट का छोटा सा बिजनेस था, लेकिन उसके बाद में उन्होंने जो बिज़नेस है वो एक्सपेंड करा और उन्होंने कंपनी जो है एस्टेब्लिश करने की सोची. अब कंपनी एस्टेब्लिश करने की सोची तो अब उसमें मेंबर्स और डायरेक्टर्स और 7 लोगों की जो ज़रूरत थी पब्लिक कंपनी के लिए मिनिमम, तो उसने क्या करा, जो सारे के सारे जो लोग थे अपने वो घर के मतलब फैमिली मेम्बर्स को ही बनवा दिया, जो उनके डायरेक्टर वगैरह जो भी थे सारे, और सो मेजोरिटी ऑफ शेयर उनके पास ही रहे सिक्योर्ड होल्डर, मतलब कि वो खुद ही थे, सारा मतलब मैनेजमेंट उनका ही था और शेयर उसने अपनी कंपनी के जो है शेयर भी खरीद लिए. अब कंपनी जब बहुत ज़्यादा मतलब लॉस में चल रही थी तो उन्होंने वाइंड अप की सिचुएशन में क्या करा, उन्होंने अपने लिक्विडेटर से डिस्कस करा और फिर उसके बाद क्रेडिटर्स जो थे वो पैसा मांगने लगे कि भाई आप मतलब आप ही की कंपनी है और आप ही जो है शेयर होल्डर हैं, और ऐसा कैसे मतलब वाइंड अप के सिचुएशन में हम मतलब जो शेयर होल्डर्स हैं वो उन्होंने पैसे की डिमांड करी. ये सालमन वर्सेस सालमन का जो केस है ये एग्जिस्ट में आया. इसका हेल्ड एक बार पढ़ लेते हैं हम. द हाउस ऑफ लॉर्ड्स रिजेक्टेड द कंटिन्यूशन एंड हेल्ड दैट वंस ए कंपनी इज इनकॉर्पोरेटेड इट बिकम्स ए डिस्टिंक्ट लीगल एंटिटी सेपरेट फ्रॉम इट्स मेंबर. द एक्ट्स and liabilities of the company cannot be regarded as those of its shareholders. So the House of Lords gives a historic decision. They said once a company is registered under law, it becomes a separate legal entity. It is like a new artificial legal person. The shareholders are not personally responsible for their company debts. Their liabilities is only limited to the shares they hold. They do not have unlimited liability. So the concept of separate legal entity came into existence. So from the case of doctrine of corporate personality was established. That means a company has its own legal entity, can own property in or its own name, it can sue and be sued. Shareholders are protected with the limited liability. So friends, this is why Salmon versus Salmon is called the cornerstone of the company law, because it confirmed that a company is separated from its member. I hope you understand this. If you found this explanation helpful, don't forget to like, share and subscribe to the Ajay Sharma Law for more easy legal cases explanation. See you in the next video. Bye bye guys. Thanks for watching.